Excellent.
Yeah.
Excellent. All right, let's begin then. Make it big. All right. So I can't actually see your comments if you leave comments, but well, actually I could. If you leave comments, I'll check occasionally to see if you've got questions or anything. But also feel free to interrupt or maybe alert the moderator if you want to interrupt. If there's a question or something that's not clear, or if my internet goes funny. So what we're going to do is we're going to use this example here. This is a patent that was granted 2 years ago now. Oh, 3 years ago, in February 2017, and I'll use this as sort of an example of what to do and how to do it. And there won't be any substantive discussion today like the patent drafting and all that, but that of course is sort of a foundational requirement, right? You can't file a patent without having drafted it first. Well, I suppose you could do, you can be an associate international associate for people who want to file in Kenya. You can do that, and then you're not drafting patents. But for the most part, you're going to have to draft a patent, and then before you can do any of what I'm going to talk about. So this was filed in Kenya in 2012 by myself and the inventor, and so which included some international filings, which is why I will use it as an example. Not all patents take this long to prosecute, but some of them do. So, oops. Okay, good. Here is just the front page of the PCT application, the international filing, and I think I have a blown up version of it. Yeah, so if you ignore the drawing part, at the bottom of the front page, you get this. And so I see it's a tiny bit fuzzy. Apologize for that. But this is basically this is the, well, okay, you'll see what it is over the course of the talk here today. But this is sort of, it all goes back to this. It goes back a little bit further, but this is sort of the pivot point for most things. Okay, so a very important front page. All right. Before we do anything, though, there's a concept that I need to introduce and I need you to understand, and it's not always the most intuitively obvious concept. Some people don't get it right at first. So if you don't get it, please let me know. I'll explain it again, or maybe in a different way, or whatever. But this is absolutely fundamental to the process, and it must be understood. Okay, the concept is that of claiming priority, or having a priority claim. An application claims priority is the way we say it. So throughout the course of any specific invention in the patent application for an invention, there may be numerous filings. Of course, there could be just the one. You do one filing and you're done. But that's not of interest to us today. So there may be many filings, and probably the most important thing about administratively, the most important thing about an application is the priority date. The priority date is the first date that any application can claim priority to, the earliest date. When I say first, I mean the earliest. Okay, so if I file an application today and it does not have any priority claim at all, then the filing date is today. The filing date is today if there's no priority claim. Okay, so that's pretty straightforward, right? The filing date is the date you file. Very, very simple and obvious. But the filing date may then differ from the priority date. Or yeah, so the filing date will always be the date that you go to the patent office and give the application to the patent office. That's the date of filing. But you might be able to claim a priority date that's earlier, an earlier filing date, an earlier priority date than the filing date. Okay, so let's say I file an application today and it claims priority to another application that's already on file. Then the priority date of my application filed today is the filing date of the priority application that was previously filed, okay? Let me rephrase that. Let's say and in fact, I'll use an example here. Go back here. You can see, although it's a little fuzzy, I apologize. In about the middle of the screen there, under number 30, tagged as number 30, you'll see priority data. Okay, so this PCT application, and I'll explain this again as we go through, but this PCT application has a priority claim. It claims priority to another application that was filed, in this case, in Kenya. And in fact, there's the Kenyan priority application number. It's KE/P/2012/001702. Okay, that's the priority application. And so this application, this PCT application, which you can see a little bit higher up, the filing date, which is under number 22, is in 2013, April 8th of April 2013. That's the filing date. That's when we went to the PCT application office and gave this application to the PCT. Not literally, we didn't actually go to the PCT, but we filed this on that day. But we claimed priority to this earlier application that was filed in November of 2012. So the effective priority date of this application is the November 2012 date. Now, why is the priority date important? It's very important for a couple of reasons, but most importantly is examination. Okay, the patent will be examined, and well, unless it's utility model, it's a patent. It will be examined by whatever patent office. It doesn't really matter which one we're talking about. And when they do an examination, they'll look at the substantive requirements of patenting, which are, as I'm sure you know from other presentations, their novelty and inventive step and industrial use. They will do that examination, and they will look for what's called prior art. Prior art means publications that they can use to say, look, you don't have novelty, or you don't have inventive step. This was done before, in other words. Someone else did this already. What you're trying to patent, someone else did it already. So what does it mean to be prior art? It means prior. Well, prior to what is the question. And prior art is art or publications that come before your application, okay, prior to your application. Okay, but what application? The priority date or the filing date? So the prior art always means earlier than your priority date, the date of the priority claim or the application to which you're claiming priority. Okay, so back to this application here, the priority date is 2012 because that was the claim, that was the application we filed in Kenya, and we're claiming priority to that application. That means that prior art has to be before 2012, November of 2012. If there's something that was filed in January of 2013, you'll see that's before the filing date, the international filing date, but after the priority date. It won't matter because we have claim priority. That publication will be ignored by whoever is doing the examination. They will look from 14th November 2012 and backwards through to the beginning of time. They won't look at anything after the 14th of November 2012, even though we didn't file this application with the PCT until 2013, because we have claimed the priority of this earlier application. Okay, so that's the concept of priority. And it's, if you don't get that, we can't really do anything else like that. It's so key and fundamental to patenting. If you don't get it, we need you to get it. So well, maybe we'll go a little further and see if just in case some of you don't get it or haven't gotten it, sorry, we will continue to talk about it, and hopefully it'll click. Sometimes the filing date and the priority date are the same. So, for example, the Kenyan application that we filed, this KEP/2012/001702, that has no priority date different from a filing date. The filing date and the priority date are the same. It's the first application. So the priority date and the filing date are the same. But many times the priority date will be earlier than the filing date. Okay. Very, very important concept. All right. So with that, let's talk about process. The process always starts with a filing, a first filing. And this, in fact, will form the priority date. Okay, so you will have to file this in Kenya for the most part. If you're, well, I guess we have a Cameroon colleague online. He can file it in Cameroon or in Oapi, actually. The rest of you, though, unless your client resides elsewhere, which is possible, if your client resides elsewhere, then you file it elsewhere. But if your client resides in Kenya, then you have to file it first in Kenya. And in fact, that's the law. And if you break that law, it's like, I think there's a penalty. I don't remember what it is, but it's there's some sort of penalty. You must do it. The other option, though, if you don't want to file in Kenya first for some reason, and there are reasons not to, you have to go to KIPI and ask for what's called a foreign filing license. A foreign filing license just requires, I think it's a one-page application. You say, I want to file this elsewhere without filing first in Kenya. And then KIPI will decide whether it's allowed or not. By the way, the origin of that you're supposed to file first in your home country, there are probably many, but I imagine, well, the one that I know of is that particularly during the Cold War, or, well, any wartime period, but particularly during the Cold War, the United States and Russia, of course, were having a little spat, or what do they call it? A row. And so what they didn't want was you file a patent application. The problem that they had was patent applications become public, always become public, almost always become public. So what they don't want is someone going and filing somewhere else on an invention that may have strategic importance to your country. And so what they demand is you file it first in your country of residence, and let the country representatives have a first review. And they can actually say this cannot be, in some countries, they can say this may not be filed elsewhere. In fact, I've had this experience where the United States will put a secrecy order on a patent application. Normally, these relate to technologies that are sensitive to security issues. So I was working on a patent for explosives, and the government didn't want this technology to be known beyond. They wanted it to remain a secret, the explosive technology. And so they slapped a secrecy order on it, and it stayed that way for a very, very long time. In fact, it still may be there, I don't know. And you just basically get stuck at that point. You don't get your patent, they don't publish it, you can't file it elsewhere, it's basically stuck. So you don't want that to happen, but all countries want the ability to say, no, you cannot file this outside. So the same is here, some is true here. You have to get permission to file it abroad. Permission is either through a foreign filing license, or you file it first at KIPI and then wait 6 weeks. If you have not heard anything after 6 weeks, I think the filing license is automatic, or the requirement for getting a filing license dissolves. So file first in your country of residence, always. Of the inventors, that is. Okay. If it's in the name of a company, I believe that you have to file first in the residency of the company. I'd have to check that, but I think that's the rule. File first in the resident of the company. Yes, that must be true, because I think I've done that before. Anyway, check on where you need to file. Second, the application forms the priority date. So this is the first filing, it will be the priority date. For any future applications that come along that are related to this application, this will be the priority date. And that means that as of the date you file first, your first filing, all prior art stops at that date. Okay, anything previous to that qualifies as prior art, but nothing after that. So when you file your first filing, you have two options. You can file either a provisional or a final application. Actually, you have two additional options. In Kenya, you can file a patent or a utility model, and there are all four permutations of those two and two options. So you can file provisional utility model, final utility model, or provisional patent and final patent. All those four options, you have to decide which one you want. The provisional application, as I'm sure you know, expires in 12 months and does not get you any rights other than holding a priority date. The final application progresses onward in the process. And if you file the provisional, you have to file a subsequent final application in order to get any patent rights down the road. But the provisional will be your first filing. It will be your priority date. Final applications can also be first filings and can get you a priority date. Either way, option 1 or 2. Okay. Next. So you have filed your first application. You've gone to KIPI, you filled out the forms. I'll talk a little bit about forms at the end. Not too much about forms, but a little bit about forms. But anyway, let's ignore them for now. I see my connection says it's unstable. I will wait and see if it stabilizes here before I abandon this one. Please let me know if it doesn't improve, but I'll talk very slowly. The international application is the second step. So you have filed your first application. Let's say you file that today. Okay, we're back on step 1. Your process, step 1, you've done your first application. Let's say that's done today. Okay, so 23rd of September, 2020. Okay, that's your priority date of the date of your first filing. Let's say it's a provisional application at KIPI, country of residence, priority date, okay? Now, your second step comes due not later than 12 months from the first filing, meaning not more than 12 months from today. You can do your second step anytime in between, but you must do it by 12 months. If you miss this 12-month deadline, this is one of the worst deadlines to miss. There are some patent deadlines that you have ways of overcoming if you miss them. This one you don't. If you miss this first filing date, you are up a creek without a paddle, as we say. Okay, so don't miss this one. This one is super, super, super important. And it's the deadline for the PCT. Well, you've got two options really, and then the third option is the combination of the two. You can, and we'll go over the two options. But anyway, this is due 12 months from the first filing, regardless of whether the first filing was final or provisional. Okay, that does not matter. These are for international applications. Now, as a side note, although this isn't an international aspect, let's talk a little bit locally. If the first filing was a provisional, you have 12 months to file the final in Kenya. Okay, and the final will then claim priority to the provisional. Okay, so if we filed the provisional today, then by the 23rd of September 2021, you have to file the final application in Kenya. Okay. Now, option 1, so now we're talking about internationally. Let's say your client wants a patent in, I don't know, Peru. No, Peru is a bad example, sorry. Brazil and Russia, since Russia is on the mind. Okay, so your patent has been filed in Kenya, first application. Your client wants Russia and Brazil as well. Okay, your two options come within 12 months. One is you can file directly in Russia and Peru. Did I say Peru? No, Brazil, sorry. You can file directly in Russia and Brazil. So that means you go to a Russian law firm and you say, hey, I've got this provisional application in Kenya. I want to claim priority to it with a filing in Russia. And the Russian attorneys put together the application, the right forms, they file it in Russia, and they claim priority to your Kenyan provisional application. So Russia then does an examination on the Russian application using the filing date of your application. as the priority date. Okay, so all of the prior art is up through today's date. Even though you have filed in Russia a year from today in 2021, they don't look at anything that happened in 2021 or the last part of 2020. Okay, that's your first filing. That's your first option. That's the way it used to be done and that was the only option to do it. Okay, under the Paris Treaty. Until the PCT came around, that was the only way to do it. And it was very tedious because the problem with that is that within 12 months, you have to know, oh, I want Russia and Brazil and nobody else. I don't want a patent in America. I don't care about America. I don't want Canada. I don't want Tanzania. I just want Russia and Brazil. You have to know that within 12 months, and you maybe don't know that within 12 months. So, so there's that problem. And so the nice folks at WIPO came along and said, we're going to create a treaty. We're going to create a system that allows for international filing. International filing. It is not an international patent. I'm sure you all know this. It is not an international patent. They don't grant patents. They only allow for filing patents. So that is option 2 on your screen here. Option 2 is the PCT. And this is also due within 12 months of your first filing. Your first filing. Okay, the PCT application is filed just like any national application, but it's just done through a special system called the PCT. You can do it directly to Geneva. We can do it directly to Geneva, or you do it to KIPI. You apply it to KIPI, and they essentially receive the application and forward it on to Geneva. And then KIPI becomes the receiving office. But I like to do it through Geneva directly. There is an online filing system, so why not? Everything is very well facilitated that way. So, so that's option 2 is PCT filing, and we'll talk about that extensively in the next few slides. The third option is a combination of the two. You file PCT and you file in some selected countries. Those would be countries you know for sure at 12 months after the first filing, you know for sure you want these countries and you want to start them early. You want to get them going now rather than waiting a few extra months or a bunch of extra months. For example, now this often happens where people file in the home country as well as the PCT. So if I'm working in the US, they will file a PCT application and a US application at the same time, the 12 months after the first filing. Or in the Kenyan example, you file your first application today, 23rd September, then in 12 months you file on the 23rd of September or before, you file both a PCT application and a Kenyan final application. Why do people do that? Mostly to get the Kenyan application to start earlier and to go through the process earlier. And also, if you go through that route, for the countries that you file directly, you don't have to bother with the PCT route at all for those countries. So, for example, you don't need to, well, there are certain benefits, but I don't need to get into. But anyway, so that's the option 3. It's a hybrid of option 1 and 2, and it's probably the most common way of doing it. Okay, let's move on. Direct filings. Oh, I already talked about this. So you claim priority. This would be you're in Kenya, you have a Kenyan provisional application, and you want those 2 countries I mentioned. You want 3 really. You want Kenya, you want Russia, and you want Brazil. You file in those 3 countries within the 12 months, and you know for sure that's what you want, and then you just do it. Directly filing, claiming priority to the first Kenyan. So this is slightly riskier than the other route, than the PCT route. Why? Because you only have 12 months to do all your filings. And once you're done, if you have not filed your PCT application in those 12 months, you decide only to go the national direct filings, you're set. You have no option to change that decision after 12 months. On the 24th of September, 2021, if I haven't filed my PCT application, too bad, you can't anymore. And that can be devastating, particularly if you're, mostly if your first filing was a final application, or you have any final filing applications on file at the time, because those final applications get published, and so they will all become prior art. If you ever want to try and file the PCT later, you would miss you have missed the 12-month window. You can no longer get the priority date, which means now everything you've already done is prior art to what you'll do later. Big problems, very dramatic, result in lawsuits all the time for liability. So yeah, don't do that. And then this, of course, the direct filings often include a filing in your home country, as I said. Okay, I see we're running down to 40 minutes, but we'll just keep going, and then Fred, you can sort of barge in when you want me to pause. This is the direct filing route. This was option 1. Okay. Now, option 2, PCT route. Again, you claim priority to the first filing, but you file, your second filing is your PCT application. Okay, then that's done again in Geneva or in Kippy. It is going to be more expensive if all else remains constant. In other words, you file in Russia and Brazil ultimately anyway, then there's an extra route of extra filing fees of the PCT application. So you've added those fees in. But on the other hand, you might decide in the extra time that you've bought through PCT, you may not want to actually file in Russia. Or maybe you actually, yes, Fred, did you want to pause here? I see we have a minute left.
You can raise. Hello?
Yes, Fred.
Yeah. I just wanted to update everybody that in 1 minute or less, we shall be off. But then they should not go away, because I will invite you within seconds to log in afresh. This is for those who came in late. Yeah, can proceed.
Thanks, Fred. Make sure you send it to my email so I can make sure you email it to me so I've got it on my computer, not my WhatsApp. Okay. Back at the ranch. So the PCT route, what it does is it buys you an extra 18 months, for making the decisions of national phase filings, the national filings. Okay. From the date of, well, it's 18 months from the 12-month date after the first filing. So in total, from the very first date, the first filing, you will have 30 total months, 12 and 18, 30 total months from the very first filing, which remember was a Kenyan provisional application. After 12 months from that, I filed PCT, and now I have 18 more months. This priority data under section 30 here, this priority data could be a provisional or a final. It doesn't matter. Okay, we can claim priority to a provisional or a final in the subsequent applications, particularly in the PCT application. If you file a Kenyan application, a first Kenyan application that's a final, can you file a second Kenyan that's a final and claim priority? Under certain circumstances, yes, but that's kind of weird. It does happen, but it's a little strange. But anyway, the first filing can be either final or provisional. Okay, I think we have almost everyone back, so
yeah,
let's move on. We were done with direct filings. We're at the PCT route. Now, what I was saying when we broke was sort of, why do we do this PCT at all? Well, there are a couple of reasons, but the most important reason, I think, is that it gives you an additional 18 months to make the decisions of the national phase filings. Okay, if you file in Kenya and today in a provisional application, and you're going to have to decide, do I want to file in the United States? Do I want to file in the European Patent Office? Do I want to file in Japan, China, all these different filings? You want as much time as possible to make that decision, because those are very expensive applications, right? To file in Japan is very expensive because you need to translate the application. And the same in China. The filing fees are low, but the translation can be very expensive depending on how long the application is. In the European Union, the filing fees are very high. There's no translation necessary until you maybe have to translate the final claims into two different languages. They always require 3 languages, but anyway, the filing fees are relatively high, and you can spend, you know, 4 or 5,000 US dollars just on filing fees alone, or lawyer fee and filing fees put together for these national applications. And so you want to delay that as long as possible, because you may discover something in your ordinary business that tells you, oh, Europe is not a very important market after all, let's not file there. Or you might discover, oh, Europe is an important business destination for this particular product. I'm glad we've got this extra time and we've now discovered we want to file there, let's file. And then ultimately, if you're working for businesses, the business will pay for the filing fees. But if you're working for a university or a research organization like ILRI or ISIPE or something like that, I would encourage them strongly not to pay for those fees, but to find a licensee. And it takes a lot of time to find licensees for technologies. So with this, you get extra time to find a licensee. The licensee then can be asked to pay for the patent fees. ISIPE doesn't want to spend $5,000 per country to get a patent application on file, especially when it's very likely or possible that technology may never be licensed. If after 30 months you haven't licensed it, well, there's a growing likelihood that you'll never license it, which means you'll eat all those fees, which is a lot. So they want that extra time to make the decision on national phase. The PCT details. All right, when you do file at the PCT, remember this is within 12 months of your first priority application, you need to make some decisions. One is a receiving office. As I said before, you can file it in Kenya through KIPI. You can also file it directly in Geneva through the e-services, I think it's called. No, something. Anyway, the PCT e-filing system. E-services is a repo. Anyway, they have an online system, and you can file it online through. So the receiving office, the RO, either is Geneva, what's called the International Bureau, which is basically Geneva, or KIPI. You also have to pick an international search authority, an ISA, International Search Authority. The International Search Authority will do the search, amazingly enough. They will be the patent office, that's the one that you designate, to do the international search during the PCT phase. Now okay, let me explain that a little. So I told you that the main reason to file a PCT application is to have your extra 18 months to decide. There's another real important component to that, and that is that the PCT will conduct a search and examination of your application as filed at the PCT. This is a non-binding search, though. It is basically, you've designated a search authority, and you're asking them to make a sort of a best estimate, a good guess of, is this patentable? You do your own examination, PCT, even though when we do enter the national phase and file our applications nationally, none of them are beholden to follow the search and the examination that was done in the PCT. They can, and often they will, but they don't have to. They can do their own search. They're free to do that if they prefer. So you have to pick, though, an authority to do the search. And in Kenya, there are, I believe, 5 options when you file through the PCT International Bureau. One of them is like Austria, and it's really bloody expensive. But then there's China as an ISA is an option for us as well. And China is cheap, very cheap. Now, cheap, you get what you pay for kind of thing, right? So if you pick China and they do the search, that search may not actually be used in your national phase applications. They may say, oh, this is done by China, I'm not going to follow it, so they'll do their own. On the other hand, China has improved substantially, and their searches I have found lately have been as good as anyone else's. For a long time, the joke was the United States. They had terrible searches, and the Europeans did the best search. I think China has improved quite a lot, and so even though they're still cheap, um, their searches are very good. That does not mean that other patent offices will follow it, though, right? So you might get your search results from the PCT phase, and then in your national phase, the searches are totally different. Uh, that's possible. Okay, so you pick your RO, you pick your ISA, you pay your fees. There are always fees. Everything patent people do is based on fees. Patent offices are very good at collecting fees. So then after you've done all that, which is usually, that's the 12-month deadline stuff that happens 12 months after your first application. Oh, and by the way, PCT applications do not have to claim priority. So you can file a PCT application at any time. There's no 12-month deadline if you're not claiming priority to an application on file, right? Then you only have to worry about, prior art and whatever that is based on your filing date at the PCT. Okay, so then after your filing at the PCT, that's 12 months after your priority date. Then within 6 months, you will have the PCT application will be published. It's 6 months because it's done 18 months after the first filing date, the priority date, right? So remember your priority date is today, let's say. Our PCT application is due 12 months from now, and then that'll be published 6 months later, so 18 months from now. It's always published 18 months after the priority date. In addition, around that time, not necessarily at that time, but around that time, you will get these other acronyms, ISR, IPRP, and WO. What are these? ISR is the International Search Report. The International Search Authority conducts a search and it issues a search report. That basically just lists the prior art that was found in the search. Okay. It also issues an IPRP. This is the International Search Authority will issue an IPRP and a WO. That is an International Preliminary Report on Patentability. Preliminary report on patentability, and a WO, a written opinion. Okay, these two together basically form your examination report. Actually, the three of these, the search report, the IPRP, and the WO, together, that is an examination report. It basically is whoever did your ISA picked up your application, searched for everything they could find before your priority date, wrote out what the references are, and then did an analysis of your application versus those references that were found. Do they destroy novelty or inventive step or whatever? This claim is not novel over this particular application that was found in the search. Okay, so they'll look at substantive rejections, novelty, and inventive step. They will also look at unity of invention. Are you claiming too many inventions? You've got 20 claims, and those 20 claims are covering 2 or 3 different inventions. That's a possibility. You have to deal with that. Okay. Sorry, it's a little windy here, so my hair is going all over. All right, moving on. So that happens within around 18 months. And then, oh, here's an example, right, I wanted to show you. Here's an example, the IPRP, Preliminary Report on Patentability. Try and say that 10 times fast. And then this is what it looks like. This is what it looked like for the patent, the Kenyan patent that I showed you earlier. That was the first, that was the Kenyan version, but this is the international stage. And this is what the IPRP looks like. This is also, then here's what the written opinion looks like. Okay, the written opinion. They will often find references and say you lack novelty, you lack inventive step, whatever, blah, blah, blah. But that's just their opinion, right? So the patent offices that you file later on, the patent offices where you file national phase, they can follow the written opinion or not follow the written opinion. It's not binding. Oftentimes they will, but it depends on who is the search authority, and it depends on who the national application is with. Okay. In this case, 4 references were found, D1 through D4. Then there's several. I only showed the first page of the written opinion, but there are a bunch of pages that explain why we our application was not novel, not inventive, etc. At this stage, you can submit amendments to the international application. You can submit amendments in response to the written opinion and the search. I almost never do. I almost never do. In fact, I can't even think of a time when I've ever done it. For 2 reasons. One is it's added expense. You file all these documents with the PCT. The only benefit is that those amendments will then go to the national phase applications uniformly, so you don't have to do them later. But that's a benefit and a drawback. And in fact, it's the primary drawback, is that now all of your applications that are filed later, your national applications, have the same amendment. And yet, as I said, the written opinion is non-binding. So some countries may decide not to even follow the written opinion and do their own search and find their own different art and make their own rejections. And so every country has its own patent law, and every country has its own patent practice. The amendment you have to make in one country may not be required. Something else may be required in another country. It might be more or less restrictive. So I cannot think of a time I've ever responded to a written opinion. You get the opinion, and it's very good to help you to help your client decide, oh, there's a lot of art cited here. Maybe we shouldn't file and spend the money on national applications at all. Or they might see and say, oh, no art was cited. I've had this before. No art was cited against us. It's a clean application. We're very likely to get a patent. So let's file even broader than we were planning to. Even more countries. This is very encouraging. More often than not, it's the former, but sometimes it's the latter also. Okay. Now, so you've gotten your written opinion. You've done. Let's go back here. You've done your publication. Your publication has happened. You've gotten your research, your search report, your written opinion. All that has happened. Now, within 30 months, 30 months from the priority date. So in the case of a filing, that would be today. 30 months from today, September, October, November, December, January, February, March. That would be March 23rd in 2023. No, 2022. No, 2023. 2023, March 23rd, 2023. That's 30 months from your first filing date. You then have this new deadline. And these are sort of this is the second most important deadline. If you miss this, you're even more screwed. Actually, it's the first most important deadline. The other one is the 12-month deadline is also very important. However, with the first deadline that I mentioned, the 12 months, if your first application was a provisional, not all is not necessarily lost, because the provisional application will just go abandoned in the 12 months. If you realize on the 12-month plus 1 day that you forgot to file PCT, you can go and refile the application without the priority claim. The problem with that is if anything happened in those 12 months, then you're screwed. If you talked about your application in the media, or you launched a website, you might have screwed yourself that way. But if none of that has happened and the 12 months are clean, nothing has happened, because that application will never be published, the provisional is not published, so it basically remains confidential, you can still file another application. In this case, this is the 30-month deadline. If you miss this deadline, you are royally screwed, really screwed, because the publication happened at 18 months, right? So if you now miss the national phase deadline and you basically filed a PCT and got no national applications out of it, you can't go and refile the PCT because your PCT was published. It will be prior art to anything you do anywhere. So you are completely up a creek in this case. So within the 30 months, it doesn't have to be at 30 months, it can be earlier, but not later than 30. And in some cases 31. So you have to go to the PCT website and find out, is country X applying 30-month deadline or the 31-month deadline? So for example, Kenya applies 30 months, and strangely enough, Aripo applies 31 months. So if you miss Kenya at the 30 months, you can actually still get an Aripo application that covers Kenya, strangely enough. But anyway, check to see which one it is, 30 or 31 months for your countries of choice. Oh, one small detail, which I wouldn't even mention in America, but here I must. There's something called a Chapter 2 demand, very outdated. Only 3 countries in the world apply the Chapter 2 provisions, and Tanzania and I think Uganda are 2 of them. So in America, where nobody cares or knows where Tanzania and Uganda are, this is never an issue. But here it is. Some clients might actually want those countries. Check to see, just make a note, check to see if they want Chapter 2 countries. And those, and I don't really want to get into the details. It's ridiculously archaic and complicated, but just make a note to yourself. If you have, if your client wants those 3 countries, there's like 3, and I'm pretty sure Tanzania is one of them. I think Uganda might be one. I don't even remember the 3rd one. It's very, very esoteric. Anyway, I can address that in the questions if we have time and if people are interested. But anyway, for every other country in the world, it's either 30 or 31 months. China actually allows 32, and it's the only one I know of. They do it because of translation time. They give you extra time to do translations. Check the countries you want ahead of time. Make sure you know what the deadline is, and then you go and file. How do you do that? Well, you have to find a local counsel. You find a lawyer in Russia, again, Russia, and you say, oh, we want to now file this PCT application in your country, and here's the PCT number, and pretty much that's all you have to do, really. You may have to file like a power of attorney or appointment of agent or something like that, but the process is super simple because all that documentation is now with Geneva and the PCT application. So the process of filing is very simplified. You just tell the lawyer, your local lawyer, I want to file this application in the national phase. And they say, sure, send us your fees, send us our fees, send us the patent office fees, and we're good to go. And maybe this one other document for appointing us as your agent. There are some nuances I'll just mention briefly, like in the US, there are a couple of choices you have to make. Do you file the application as a national application of the PCT or only claiming priority of the PCT? Very technical. You don't really need to know this because the United States Council would be the one to do that anyway. But the point is that you do need local counsel because there are sometimes some decisions that have to be made. And in any case, most, if not all, patent offices require local counsel for representation in any way. So you'll need that. This, though, the 30-month filing is called a national phase filing, and it is the start of the national patent application process. Right? This is what would have been done under option 1, way back in one of my earliest slides, option 1, direct filings. This is that, but now delayed another 18 months, and you still have to go through national offices to get patents in the national countries. Right? So there's no difference, actually. Well, okay, there's a slight differences. I mean, the one nice difference is you don't even need to send the application itself to the local council because they'll get it through the PCT online system. But the most important difference is it's happening 18 months later, the national patent process. So basically what will happen now is Russia will start the national patent process with this PCT national phase entry. They will do their examination. They will, grant the patent or not. because it has not even started for 2.5 years after your first filing, it's very possible that your patents in other countries might be 3, 4, 5, 6 years after your first filing. It might take that long to go through all this process. It's very nuanced, shall I say. Here's so we did this in the same example that I had the Kenyan patent. Here's the ARIPO equivalent. Okay, so we filed it in Kenya first, we then filed in the PCT. From the PCT, we filed in ARIPO. And you can see they've got the filing date and the priority date listed separately. Actually, I believe in this case, we filed ARIPO directly and PCT. So it's so the filing date of ARIPO matches the filing date of the PCT, but that's not too important. Let's see. So that's that. This is what it looks like when it was finally granted. You can see it was granted also in 2017. So that's 5 years after the priority date. Both Kenya and the ARIPO took 5 years essentially for the whole process to go through. Not unusual. So here's the timeline in a nutshell. We filed in November, the first Kenyan application, November 2012. We filed the PCT application in 2013. We also happened to file the ARIPO application on that day. Remember I said there's the hybrid PCT plus some national filings. Well, ARIPO, we did that, and ARIPO was one of those. The PCT was published 18 months after the November 2012 date, which would have been 22nd May of, it wasn't exactly 18 months, it's close to 18 months. A little bit after, I think they're only done once a week or something like that. On 2014, and then in 2015, which is 30 months after your filing date, you had your national phase deadline. Okay, 14th May 2015, and finally granted 8th of February 2017, similarly with ARIPO. Okay, so that's that in a nutshell. Just a few last things. Documents to file. So when you do file, I said I'd talk about forms. Not too much though, because forms you could talk about forever. There's so many forms. Every country has forms. We have forms. PCT has forms. There are lots of forms. So know your forms. There are also online systems. So the PCT has what is called the request form. Here's an actual example of it, PCT request. This is the most important document filing at the PCT, apart from the actual application itself, which has the claims and the specification, all that. This is the accompanying document. It's called the request. I think it's called RO 101 officially or something like that. It's bigger than this. I just cut a part of it out and showed it here. Sorry. There will be an appointment of agent form in most cases, or sometimes it'll be on the request form in the specific country. There's a certified copy of the provisional application. So if you file directly, if you go through option 1 and file in direct countries, they will almost certainly ask for certified copies of the provisional application. And the PCT might also ask for that depending on how you file it. If you file it through KIPI, then they won't ask for a certified copy. If you file it on the International Bureau, I think they don't. Well, they do, but you can get it sent somehow. Anyway, I can't remember the detail on that, but you will have to provide a certified copy of the provisional application in some cases. And I implore you to use these services whenever possible. They're very convenient. And most countries have them now, including the PCT. Again, here's the PCT request. It's actually nowadays it's done on, well, if you file it through e-services, they don't even use the form anymore. You fill in boxes online, and it generates the request from that. And then I think lastly, this is just an example of the substantive examination report from Kenya. You'll see our first examination report, we had a lot of claims were rejected. Down, if you see at the bottom, statement on novelty, inventive step, and industrial applicability, we got a report back that a whole bunch of claims were novel. All the claims were not inventive. Some of them were not novel. Well, we argued, we amended, we came to an agreement with Kippy. Never take the examination report lying down. Always fight back. Always try and get your client as much as you can. And I see we only have 9 minutes left in this session anyway, but that's really all I have to present. And I left a bunch of time for questions because some of this stuff is very nuanced, and I'll address it if, however you like. So there you go. Back to Fred, the moderator.
Okay. Thank you. Thank you, Dr. Isaac. I think that was a very good presentation. So I know we have less than 8 minutes, but I think we should use this time for discussion, comments, question and answers. And I think people have been chatting. So maybe I'll invite Dr. Isaac to start with the chat questions, if any. I don't know whether you have some on your end.
Actually, I don't see any. Maybe I'm not seeing them. I don't see any chat. Anything.
No, they disappeared with the first.
Oh no.
I get you. I get you. So those who had the post questions maybe can now repeat that we can get them. Or observation. Yes. And carry up your hand. This one.
You know, Fred, I don't know whether you can. I can't see my video here at home is not showing. I can't see.
Are you able to carry up your hand?
I can carry the hand, but
not physically.
Are you able to see? Yeah, I'm seeing. Where is this thing? It is not showing on my.
All right.
But anyway, I'm here. I'm listening. So I will raise my voice in the event I have to ask a question. Maybe I'll have one question later on.
Okay. Continue. Yes? Oh, Moses, I thought you had a comment or a question.
Oh, no. Okay, let me just ask what I wanted to ask anyway. It's just an observation.
Yeah.
From what Dr. Rutenberg has presented, it has become very clear that being a patent counsel or lawyer representing a patent applicant requires you to be fully aware of the pitfalls that attend to the filing process. And I'm seeing you mentioned 3-4 times about the possibility of lawsuits being filed for liability, and I'm saying I don't know how many of us in Kenya are aware of this pitfall and whether they've come across. I haven't done it, but from what Dr. has just said, I think it is something that we need to start thinking about in order to render good service to the clients. So that is all I would want to say.
Yeah, that's true. Yes, Dr.
Oh, I couldn't agree more. I've seen some pretty hefty lawsuits based on mostly on missed deadlines in patents, and so you lose a patent in whatever country, and all of a sudden that becomes your most important market, and now you're out all that money. So yeah, this is some serious liability problems, potential liability.
Yeah, and just to add on that, it's very important actually to learn about international filing, and the patent drafting is actually a must. I should agree with Dr. Isaac. It's very difficult when the client asks you to amend the claims and you're not able, you start looking at each other. So it's important to have all these things. I've tried working on 2 international filings, but we got stuck at the national FES. It's a very expensive FES. International is okay, but national more tedious. That's why you had Dr. saying, when you want to go to Russia, then you want to go to US, you want to go to Cameroon, you have to choose lawyers, and not all attorneys again are okay. So we have all these problems that are shit with phase 2. Yeah, so I can see another hand from Dr. Winston Ochenge, please.
Thank you, Fred.
Yeah.
Isaac, my question, I have three questions. They're very simple.
Okay.
And fast. How much time do you estimate for patent application to be granted? I saw in the earlier patent, the pen and the Kippy one that you gave us in the last files as having taken from 2012 to 5 years. Do you suppose that is
All right.
what's the time? It usually takes not that long. I don't know whether I can ask all three or one after the other, Fred.
You can ask.
Go ahead and ask them all, yeah.
Yeah, go ahead.
Okay. Then very quickly, you can explain what priority claim is. I have a feeling I understand, but I need to be sure. And then three, suppose from the initial application, 1 year, 12 months has passed from the initial application to them in Kenya. 1 or 12 months has passed. Does that mean that all your hands are now totally tied? You just have to wait out until the grant, the national grant is given. Okay, so for your first question, the time for grant, okay, 5 years is on the higher end, but it's not egregiously so. I mean, I think 3 years is 3 and 4 are probably average. 5 is on the high side, but not so much. I would say that there's something wrong with that. I think that it's okay. It really depends actually on how much. It depends on a lot of factors. One of those factors is how much back and forth do you have with the patent office. So you saw that the first patent report, examination report from Kippy was negative. They said here are what was it here? It was this one. You know, you have rejected claims, novelty and inventive step rejections. So we had to have a back and forth discussion with Kippy, and those take time. Every time you write to Kippy, you know, it'll take them 3-4 months to respond, or maybe less, but not usually less. And then you take a couple of months to think about it and respond again. And that back and forth can easily rack up to 1, 2, 3 years. And so the delay is pretty normal actually. Although some applications are starting to get fast-tracked, and utility models go very quick because there's not an examination. So remember that. On the second question, priority claim. Actually, that maybe your third question might be better. Remind me. Sorry, your third question. Can you just remind me again what it is? Suppose 1 year is passed from the initial application.
Yeah, 12 months.
Does that mean your hands are tied now? You have to wait for the national grant. Right. Right. Okay. So after the 1 year mark has passed, your options become much more limited. Okay. So within the first 12 months, you can file. For example, you can often file amendments by way of new applications. So you might be able to file, maybe your first application is a provisional, and you file another provisional 6 months later. And then 6 months after that, you can claim priority to both provisionals. You can modify, whatever. You have a lot more options. Your hands get tied for sure after 12 months. Your options are very limited. If you have filed PCT, you have a lot more options. If you have not, you really don't have any options. Think of priority claim as a placeholder application. Like you're marking your spot in line. You know how you go to the store and you're standing in line and then you forgot you wanted to get bread too, but you forgot to put it in your cart. So you say, I'm going to leave my cart here to the person behind you. This is my place in line. I'm going to go get my bread and put it into the cart, and then moving on. So that's sort of the same thing. You write your first application, you submit it to the patent office, and you say, I'm marking my territory here. I'm getting in line for a patent examination and all that stuff. And this application may or may not be complete. I try and write it so that they're full as possible. Provisional applications should be essentially the same as final applications if you can make it that way. There are some cases when you can't, but that's sort of another topic for another day. But the first application becomes your placeholder and says, I want examination to be based on this date and prior to this date. So all the applications I file after this one, they're going to look basically the same. They're going to be based on the exact same technology, but they'll be filed later. Yeah, I agree, they'll be filed later, but I want you to examine them as if they're filed on this early date. And that's the essence of a priority claim. Just saying, I want my later applications, whether they're filed again in Kenya or anywhere else in the world, I want those applications to be examined as if they were filed on this first date. And oftentimes there are some nuances about priority claim. Did you actually describe the invention in full on the first priority date? This happens if you make changes in later applications. If you file a provisional today and you file a final in a year, and there are changes to your application which are allowed, but if you make changes, you call into question, did you invent this 12 months ago? Or did you invent it the day you filed the final, right? Was it fully formed? Was it, was that bread that you forgot? Was that key to the invention? In which case you may not get the benefit of the priority date. Those are some nuances about priority date. But the essence is it allows you to hold the time of when the examination period will stop. There's a question in the chat. I see two questions. Oh yeah, okay, good questions. So in Kenya, is there a possibility of restoring the priority date? If you have lost the priority date for some reason, there are instances when you can get it back. You can, what's the term? I forget the term. Restore, it's not restore, but you can essentially restore a priority claim. They're very rare, and I've never actually done it. You don't want to ever get in a position when you have to, but things happen. And I do remember one case where this was back in the day before we had any online filing systems, even in the US. They were just introducing it and no one was using it. And we used to file things in the post office, and whenever the post office stamped the card that they would, or the package, that was your filing date. And I was in San Francisco, and there was one post office that was open until midnight, and that was at the airport. And so we'd have to drive to the airport and get that post office to stamp on to make sure we got the same date of the date that we wanted, the one that we needed, to make sure we beat the 12-month clock or whatever. And I remember one case where we missed, there was some traffic we didn't expect. We were much later to the post office than we expected. And we arrived in the post, it wasn't me actually, my assistant, arrived in the post office before the 12 o'clock midnight clock struck 12. But for some reason they didn't stamp it until like 15 minutes after midnight. And so we missed the deadline, but we filed a whole series of documents explaining what happened and saying we were there and blah, blah, blah. And somehow, I don't remember the exact situation, but somehow they gave it back to us. We were looking at a very big lawsuit for that too, because it was an important invention. So fortunately they gave it back to us. And so, yeah, it is possible to restore priority dates in some limited cases. And every country is different with what they allow. So I've never tried to do it in Kenya. I think the thing that happens here is you forget to pay fees sometimes, and there are big grace periods for paying fees. Annual fees are kind of annoying. If you forget to pay an annual fee and then you forget to pay the fine and the fee within the window, even then I think you can still get it restored. There are some rules about that. It's kind of a pain. Fred asked me to talk about fee waivers. So at the PCT, you will have to pay fees. Of course, everyone requires fees. The PCT fees can be steep depending on the International Search Authority. Like I said, Europe is really expensive. The US is kind of expensive. Others are Australia, whatever. then there's the international filing fee, and then there's the international publication fee, and all these different fees. For some of those fees, you get a 90% discount, 90, discount for being in a least developed country, or actually not just least developing countries, because Kenya is one of them. So, and we're not a least developed country. So there's a very steep discount for certain countries. I'm sure Cameroon would be considered one. Without looking, I'm sure it would be. Kenya is. So always, of course, try and get those discounts. It makes the applications a lot more affordable. I have to say, though, they're still not terribly affordable. On average, I would say my clients pay maybe $1,000 to $1,200 in PCT filing fees, not including my fees, just PCT fees for an application, and that's with the discount. The discount doesn't apply to to all the fees; it applies to some of the fees, but there is that big discount. So, which is substantial, right? Because I mean, if it weren't fee reduced, some of those applications that I would file in the U.S. were costing $5,000 just in fees alone. So it can be pretty hefty. Also, note on fees: nobody in the world files patent applications in every country except pharmaceutical companies. They do that occasionally. And those are unbelievably expensive. I remember doing an application for one client that filed in 20 countries, and the fees for that were in the 6 figures in USD. So it's expensive. It's very expensive to do this. Other questions?
Yeah, thank you. I think mine is okay. Any other question? We had one hand up just before we went off. I don't know if it's not Jared. I think it was Kamau. Okay, any other comment? Cecilia, do you have an issue or you're okay?
No, I'm okay. Thank you.
Continue. Oh.
Fred,
Uh-huh.
just as a follow-up of what I talked about, the danger of facing lawsuits. I think one of the remedies that we need to put in place is, of course, getting adequate insurance cover, the PI. And I don't know whether in Kenya, the PI is sufficiently tailored to take care of possibility of hefty damages that can be claimed in the event there is negligence on the part of an advocate. I don't know whether Prof. in the panel here today, or in participation, has any views about that. I think it is something that we need to consider as practitioners to take slightly more cover, enhanced covers to take care of any of these possible claims, because I'm really pretty scared actually about the danger of missing the deadlines. We keep missing it here for litigation. And I can imagine what happens if you're doing something which has international dimensions and ramifications. That is all I would want to make comment about.
Thank you, Senior. Should I call you Senior or Counsel? I don't know.
It's all right.
Actually,
whichever, it doesn't matter.
I like to call you sir.
Yes.
Okay.
Just call me Moses.
Let me say. Okay, then you have to call me Isaac.
Yes.
Let's see. Yeah, I think the standard malpractice here, I don't know, it's like 75 million or something like that. For most patent work that's done here, that's probably sufficient, I would say. If you're going to start doing international work, so work for the likes of IBM or pharma companies, any of these big major patent filing companies, you probably would want to look into some more of that. But on the other hand, they have to justify the fee, the claim, exactly. So you know, 75 million in a country such as Kenya might be the market. I don't know. Like it might not be too far off, but you definitely need to make sure that your liability insurance does cover intellectual property work, and that's, you know, within the policy. And then just finally to say on that, you should be worried. I mean, like it is a serious thing, and there's no leeway in many of these cases. So, you know, with litigation, it's often you get a abeyance or whatever you want, continuance, whatever they call it. I'm not a litigator, so but I guess you just get like kicked down the road a little bit longer. This, you can't do that. Like you miss a deadline and your client is out. So.
Thank you.
Yeah. I see a question here from David. Has anyone tried to file national phase entry applications in OAPI? I have had, I think, one that went to OAPI. The big problem with OAPI is the language. So, you know, a lot of, I mean, you have to get it translated into French, and that can be pretty expensive. So you have to justify the translation costs based on the market size, and that sometimes, you know, most clients tend not to do that, at least for me. But OAPI has quite a lot of files, as far as I understand. I'm not, you know, I'm sure that Mr. Boyle can actually speak on this more than I can for sure. But as far as I know, it's pretty well used. And he's saying here it has new legislation which requires national applications are published for objections before examinations within 3 months. So, sir, I think you can speak on this more than I can about national phase entries at OAPI. I haven't had more than one, I think. And Fred also says there's one.
Yeah. I filed one in 2017 for a university, but first of all, getting the person to help me was difficult. I got one from Nigeria who claimed to have links, because it's not easy to make a call or to even, let me say, befriend somebody from OAPI region. I think the way we work is...
Thank God you have David now.
Now we do, yeah.
I'm so happy. I want to get hold of David now. But we failed on a very technical area. We were not able to renew it on time. You remember the annual timelines. So when we were not able to get paid on time, they told us it's been rejected, because we had a Nigerian lawyer who had a person in OAPI whom we don't know. So we used to communicate through, so we were not able. So it's almost dead, I can say.
David, you're saying it can be filed in both English or French. Is there a point, though, where it's required to be translated, like maybe at grant?
Hello, can you get me? Can I respond?
Yeah.
Yes, please.
Okay. If the documents that have to be translated are mostly the priority documents or the assignment documents. If the priority document, certified priority document, is not in English or French, it has to be translated to one of the languages of OAPI, either in English or French. So the certified copy is priority document is filed together with an English translation or a French translation thereof. It's the same thing with the assignment document. If the inventor assigns the invention to an applicant, the deed of assignment is in other Mandarin or in Russian or in Japanese language, it has to be translated to English or French. Those are the only documents that can be filed that requires translation. The rest, the OAPI accepts them either in French or in English. But working with a local agent who understands both languages and can use both, you would not require translation and additional cost from the applicant. Some firms will charge you translation fees, but we don't, because we work on both languages.
That's very helpful. I'm glad to know that, and I think more clients here would choose OAPI if they know that. So thank you for that, sir.
And secondly, the cost for OAPI 2 is equally high as compared to the European patent filings. because of the number of countries involved. You have 17 countries. If you were to multiply to do per country, you see that it comes down to filing in a single country as Kenya or in Tanzania. But if you're filing through the national office OAPay, it covers all 17 countries. So the cost is like spread across the 17 countries. That's the reason why it's a bit high.
Yeah, thank you.
I should also mention for others in the room, Nigeria and South Africa are, neither of those are in OAPI or ORIPO. So if your client wants either of those countries, you have to file directly in Nigeria or in South Africa. Now, South Africa is quite easy. They have an online system and a lot of patent attorneys that can do it. Nigeria, for some reason, is very expensive. I have a firm I use there and they're very, very expensive. Like it's pretty crazy actually, but it's a huge market too. So, you know, it's often, you know, the value for the market is relative, I guess, but just note that.
Yeah, thank you. Yes, I can't see any hand. Do we have an issue from the chat? Let me see. Okay, maybe just to add something on what Dr. Wilson Otswong'o was talking about. The reason it takes too long, I think PCT has an advantage here. Two of the patents have gone through the route of PCT and deliberately retained Kenya. I know there is no need of designating Kenya when you have already filed Kenya, your priority. They have been examined. A very good report has come from Australia or Sweden and found the one in Kip is still lying on the desk. So the examiner has been very happy to use the international report, examination report, and fast track that because of the resources. That's the advantage of PCT, the way I saw it. They give a report that is normally recognized by most patent offices, almost straightforward. Yeah, so that's my observation there on the advantages of using PCT, especially the International Search Authority. So we continue. Any comment?
I absolutely agree with you, Fred.
David, you have your hand up. Okay. David, you have something to contribute?
I was just thinking about
Yes.
losing a priority, not being able to renew because you missed it. OAPay has a possibility where the blame is attributed to the agent or to the applicant, and you have to pay more. So it's easier when the blame is attributed to the applicant than to the agent. You have a tough time explaining why you missed, and probably your instructions came late, you had a problem with your email, or your agent had an accident on its way. So it's a bit difficult, but you have to pay more. It's than when the blame is on the local agent to restore any deadlines missed. So it's for some time I thought OAPay was just interested in the money, but I saw the value for the clients. If not to, when you miss a deadline and you have a possibility to catch up, you bear the cost, and high cost too.
Okay. Yeah, that's an advantage. Secretary.
That's good. That's also good to know. Thanks. And every country will be different. So you know, if you run into a situation like that, check with the local associate or look into the law and confirm.
Yeah.
Okay.
That's
Thank
good.
you.
Any other person? We still have a few minutes. We go to the closing session. Yeah, otherwise we shall assume that you are now educated. You will be able to take on the quiz. You will be able to take a client through international filing without having problems. Making so many calls all over, you can at least start it up. At least we know now the requirements. You have the request form, you have the appointment as an attorney, you have the ISA you have chosen, and then you pay the fees. Then from there, communications start coming up. We saw the forms there. From WIPO to you, do this, this is not, but they are very strict on the drawings. I've just been told that the drawings, when you're doing e-filing, the EPCT, we shall see it later in the quiz, the drawings must be pure black and white. So we have had issues with them because if you do a photocopy and then you scan, the degree of grayness remains always. So they'll keep reminding you your drawings are not up to date, they are gray. Please go back and change. So you have a lot of issues there. They also don't allow drawings together with the abstract, but you need to mention that you like a particular drawing to be accompanied by the abstract during publication. So that is very common in Kenya, that happens, but when the publications come out in Kenya, I don't see the drawings that we normally indicate appearing in the journal. But international standards, I think that is the practice. So the online filing is the easiest, the best, and very cheap. I think there is deduction in fees, the way Dr. told us. And you are given the number yourself directly. They only notify the RO, the receiving office. For example, in Kenya, Kipi, that Fred has already filed, so go through his application and advise accordingly. But you allocate yourself all those things you are having. Although authentication system, I saw it was very complex. You have to have three layers. They subjected me to 3, but I realized 2 are enough. But going through 3 were very tedious exercise. It took me a whole week. And fun enough, Kipi did not want to help me. They said, you struggle, you know how to read English. Try every day until you get it. So from last month, I got it on Sunday. So we were able at least to submit by yesterday, and I hope that number will be retained, especially the priority date and the number. So that's my experience with the PCT, the latest PCT system. So, yeah.
Very good, Fred and Dr. For me, I think I've had very good information. I'm happy with, you know, when I saw the biogas production filed by Dr. Rutenberg, I was interested because I remember when we were at the tribunal, there was somebody who had attempted to file something about this biogas thing, and it got stuck along the way there. It never moved. I think there was something they filed. I can't remember exactly what it was in the tribunal, but it came up for consideration, and we dismissed it because we didn't think he was going anywhere. But I'm now happy that there is a biogas, which is a patent issued for biogas production from Kenya, which is very good. We see farmers every other day. In fact, Daktari, on the issue of claiming, on the issue of prior art and the priority date, in this biogas thing, I don't know exactly how it happened because there are so many people having this technology. They use it rudimentarily at home. They even cook with it. And they do their own connections and they have something functional. I don't know whether they would be accused now of infringing anybody's patent, but I don't know. You can maybe highlight that one.
Yeah, certainly though the claims would be the most important consideration, and you know, the claims for that patent were uh, specific to the device that he had built. As for whether other people are using such device, he has complained to me many times that there are others making similar, but they use inferior product. They use inferior construction techniques, and so the device doesn't work as well. And you know, he's considered prosecution, litigation a number of times, and he's made the decisions he's made. I'm not really, you know, involved or able to speak about them, but I definitely know that it's an area of active research still, and you know, the nuances of the device are very important to whether it works well or not.
Yes, does he have a mass production now for this biogas technology that he has patented?
I haven't spoken with him this year. As of last year, I don't think so.
So he's going to use it as a shield, not as a not as a spear.
It seems so, yeah. I always thought, you know, he actually is working on really large digesters now. So the ones that are in that patent are for home use, but he is interested in really big ones for
Industrial production.
Industrial, yeah, schools and the like.
Yeah, that would be very good, actually.
Yeah.
We should talk, anyway, we'll look for him in terms of wanting for schools in our areas, because we want to minimize the cutting of the trees and logging that takes place, you know.
Yeah, absolutely.
It's
And you know, one
booming
device.
business in rural areas, yes.
Absolutely. If you've got cows. Sorry, go ahead.
Yes, I'm saying, in fact, recently after the COVID broke out here, the schools and the suppliers to schools for firewood were complaining. There is no market for our firewood. They should open schools quickly. So, but if this biogas production equipment was to be fixed in a school, then there will be nobody wanting to destroy trees and so many other. I think this is a very positive development. So we should encourage him and also to ask him not to. He can litigate where necessary, but I doubt whether there's need for him to go for the small fish, because I've seen it on TV. Some lady saying, I do this biogas, I cook with it, then I use the rest for manure for the farm.
Yep. Yeah, it's a wonderful device, and you can power a whole school's kitchen just from the cows, you know, that are on the property. So it's it's really great.
It is nice. No, especially secondary schools in Kenya, they would really benefit a lot because they have few cows. I have seen all of them. Everybody wants to have a cow too in school for purposes of supplying milk. But now if they find that the biogas can also be put into use, they will buy this equipment and then make sure that they minimize, cut off the firewood costs and instead invest in this one, which is environmental friendly and very useful, reliable, actually.
Absolutely. Fred, I have another meeting starting in 2 minutes, so I'm going to have to log out.
Okay.
Is all right? We also have, I think it's less than 7 minutes to go. So
yeah, we just summing up actually. Let's all of us thank Dr. Isaac for taking us through this very important training. And personally, I've learned now a lot of confidence in that. That when they say rejected, claims 1 up to 10, they are all rejected because of lack of inventive step. I think you can still fight back and get your patent on some claims. So I'm happy, I've learned a lot. Unless if you have something burning, yeah, I would like to wish you a good evening and hope to have a WhatsApp group, hopefully temporary for now, just to iron out the remaining issues. Otherwise, next week we shall have maybe a revision exercise on the international filing together the regional, so that we now get our participation certificates the week after. I'm happy and wish to thank you again. Ciao.
Thank you.
You're able to see
Thank
me.
you. Thank you very much. And Prof, thank you so much. We'll see you soon.
Thank you.